guys ready here?
Uh-huh.
Okay. I'd like to call the first hearing to order. If you're here for the City of Belleville Municipal Officers Electoral Board, you're in the right place. And the first, there's 3 separate hearings. We will be hearing case number 15-1 first. I'd like to, first of all, introduce the Electoral Board here. And it's myself, Mark Eckert, as mayor, Dallas Cook, my far right, as the city clerk, and Paul Seibert will serve on the first 2 hearings as the most senior alderman from Ward 6. Sitting next to me is our assistant city attorney, Brian Flynn, and so you know everybody, and a court reporter down here. I don't think I even know your name. John. Well, John's here in his capacity, and Rich Peppers is filming today's proceeding as we film our public meetings now with the City of Belleville. So we've got everybody here from the Electoral Board. We've identified them. I am going to go through and we're going to treat this as any other Open Meetings Act meeting. So in just a second, I will allow public comment. The adoption of the rules we will do after that and go through the procedure. So does anybody right now have anything that they're dying to say before the hearing gets started? And then this is on the first case, 15-1. This is the case Rafi Ovian is the petitioner objector versus Alex J. McHugh. Do you have a comment on that case, sir?
No.
Okay. So if there's no one else, I'm going to close public participation. And at this time, I'm going to ask Brian Flynn to read through and explain the rules that we're going to follow and ask for a motion here to adopt by the committee.
I believe each of the parties has been given a copy of the rules of procedure. If any of the parties have questions about those, they can pose those now. Otherwise, I think the board should entertain a motion to adopt these.
Okay, we have this. And the what will happen, the first case, as I stated, will be heard first. Each case will be dismissed and go to the next case separately. The adoption of the rules is primarily a preliminary matters motion, a presentation of the case, taking notice of the nomination papers and objection, the objector petitioner's evidence, the candidate respondent's evidence, the objector's petition's argument, the candidate respondent's argument, and then the decision, which is the deliberation, drafting of the written decision, and the vote of approval of written decision. That's the order. Do I have a motion to accept the order and the rules? Motion by Alderman Seibert, second by Mr. Cook. Any discussion on? All in favor signify by saying aye. Aye. Oppose. Motion carries unanimously. So we will now start with the first case, 15-1, and I will let you ask for, you want to explain the case first of all?
Well, I'll start with by asking either one of the parties. I mean, if the parties want to come take a seat at the tables, it might be a good idea. See the microphones, and that way everyone can hear you.
This is Mrs. McHugh. Why don't you sit in the fourth?
Yeah, once you guys take a seat, you know, if you want to sit wherever you want to sit, it doesn't matter. Introduce yourselves for the record.
Rafi, you want to start out because
You're the objector.
I'm Rafi Ovian. I reside at 8521 West Main, and I have filed as an objector and also as a candidate in Ward 4, representing the City of Belleville.
Okay.
Alex McHugh, the candidate question. I'm Tom Peters, who is his attorney. I apologize for my address, but I was only hired today.
Okay. Do either of the parties have any preliminary motions to make?
Yes, Your Honor, sir. At this point, we file a motion to dismiss the objections with respect to Mr. Ovian. Number one, it's not certified or sworn. That makes it rank hearsay, should not be considered. More importantly, if you look at the first allegation, it says candidate Alex McHugh was not a resident of Belleville, Illinois for 1 year prior to filing as a candidate for alderman in the 4th Ward, City of Belleville. That is an insufficient basis as a matter of law to exclude a candidate from a ballot. It must be from the date of the election, not the date of filing. It is a material defect in the pleading. It cannot be repaired. The second argument, candidate Alex McHugh did not obtain an occupancy permit when moving to his present address at 10503 West Main Street, Belleville 62223. While this does create the presumption of residency, an occupancy permit is not a requirement under the statute. On that basis, we would move to dismiss this objection as completely and utterly sufficient under the law.
May I have an opportunity to rebut that?
Absolutely. You have an opportunity to
Okay.
speak.
Number one, what I'd like to do, and I'm going to address everybody here.
Could you speak into the microphone,
Right.
Rafi, stay seated?
Mark, I would hope that you would recuse yourself from
So, sorry,
basically.
I'm going to interject. Just.
Well, let me get into it, and then I'll wait and answer later.
Go ahead.
Because there's some serious issues here that we need to go ahead and basically introduce. Number one, there's evidence here that basically, and I have in my possession, that Mr. McHugh basically, through the walking papers, he did not vote until the general election in November of 2014. Also, he did not register to vote until September the 4th of 2014. Thirdly, I do have documentation to show that he is not the present owner, that his mother and his father, both deceased, are and still remain as the present owners of the property. And that basically that Mr. McHugh is not the one who pays the bills for the city of Belleville's trash removal. In fact, the mother's account was closed as of October the 9th, and a late fee was paid, and it was not paid by Alex McHugh, it was paid by his stepbrother, Andy Moore. Because the mother was married twice. Once to, I believe, Robert Moore, and then secondly, in 1966, to Frank McHugh. So therefore, his statement that there's no credence that he was not a resident is not valid.
Sir, I'm going to ask you, do you want to respond to the specific defects which Mr. Peters has pointed out in your petition?
I can.
Okay.
All right. And I understand it's a legal issue that he states the date of filing, okay? He basically came on board in 2014. He was a resident of Omaha, Nebraska prior to that. Not as of the filing date, but in 2014, when his mother passed on July 18th, it listed, and I've got a copy of the obit, stating that he was a resident of Omaha, Nebraska. He was also a registered voter in Omaha, Nebraska. I have copies of that information as well. This will all be brought out later by
Sure, of course.
Jan Subcheck. So, there's sufficient information to refute what he is saying, that he's been a resident for 1 year based on the ordinance.
Okay. Do you?
If I may reply briefly.
Absolutely.
Again, what we have is a bunch of rank hearsay that doesn't matter one whit to what this body is to determine. The claim that the owner is deceased people of the home. There's no claim that Mr. McHugh is the owner of the home. I don't know where that comes from. I don't know what that matters. Deceased people don't own homes. And so whoever made that statement, it's false. Number two, doesn't pay the bills. You don't have to pay the bills. So even under the law, there's no requirement that any particular person pay a bill of any particular residence for purposes of running for office. Number three, late pay paid by Andy Moore. There's no question here that Andy Moore is a resident also of the home. There's no question about that. So I don't understand what that amounts to besides a bunch of hogwash. Number three, and this is where we have a big problem. Someone makes the conclusion that Mr. McHugh was a resident of Omaha, Nebraska in 2014, but fails to mention that there was no domicile in Omaha, Nebraska in 2014 for Mr. McHugh. That is a off-the-cuff shooting from the hip type comment, and if it was made outside the presence of the hearing, it would be actionable. The only protection for that kind of statement is that it's said at a legal proceeding. Again, also being registered to vote and voting, we know that Mr. McHugh has voted here, and whether he was registered to vote at some time in Nebraska does not matter for what we're here to decide. And on that basis, this petition must be dismissed. If the second petition is fine, then the second petition is fine. But this one is not.
I'll recommend to the board that we delay making a ruling on Mr. Peters' motions until hearing the entire case and all the evidence. So unless one of the board members wants to make a motion one way or another, I would suggest we proceed with the hearing. Hearing no motions?
Is there a motion to act on Mr. Peters' request of dismissal?
No motion to deny that, so we can hear the case.
Oh, what I'm getting at is we can delay hearing. You
That's
can
fine.
delay making
I'd
decision.
like to hear the case.
Right. Okay. So what I'm saying is we can make a ruling on that motion after hearing all the evidence, if you'd like.
Sounds good.
Okay.
Okay.
So
You agree, Mr. Seibert? So we will delay making the decision on Mr. Peters' request for this first case, 15-1. Mr. Ovian, do you have any other comments other than what you made so far?
No, but I do have documented proof that the ownership of the property is in the mother and father's name, who are both deceased. I obtained this today.
okay. Well,
From the
before
assessor's office.
you introduce that, I would ask that the board take notice of the nominating papers and the objections before we get into the crux of the case.
Okay. Beating the objection here.
Yeah. So if you just want make a motion that the board take notice of all those documents that have been filed.
Do I hear a motion to file, accept that Mr. Seibert accepts that we take notice of the documents that have been filed thus far? You second that?
Second that.
Second by Mr. Cook. Discussion on that motion. All in favor of the motion signify by saying aye. Chair votes aye. Motion carries and they're officially accepted as documentation.
Okay. Is it Ovian, sir? Is that
Yes,
your-
sir.
Okay, Mr. Ovian, if you want to go ahead and proceed with your presentation of evidence, please go ahead.
All right.
And just so you know, you will be given an opportunity to make an argument after Mr. Peters
That's
gives
fine.
his evidence. So if you just want to present evidence right now, that'd be great.
Do you want me to present the evidence to you or
To the board.
to the board? Okay. Here is documentation of proof of ownership of the property and also the land which is also owned, that's part of the parcel, which was obtained today and has not been changed. Here is also a copy of the city sewer trash account in the name of Joseph McHugh, who's deceased, whose account basically was his wife. And I have further documentation of where the account was closed on October the 9th due to basically not being paid out of the account when it was closed, and it was paid later due to insufficient funds. Penalty was charged, and both the payment for October, November, and December was paid after November 1st. That is clearly identified here from City Hall records today.
Okay, and that was paid for, you said by,
And I have a copy of the canceled checks by Andy Moore, who is his brother-in-law.
okay, you're gonna submit all that to us?
Yes, sir.
Do you have copies for
No, I
Mr.
don't.
Peters? Or you just have one copy? If you
just
wouldn't
have-
mind showing it to Mr. Peters first, and then we'll
Sure.
take a look at it.
Has this witness been sworn?
He is not.
Okay, I guess that was a mistake, we should have. Okay. Mr. Obi, before we go any further, you need to swear that the testimony you've given and what you're,
That's fine. So can you just raise your right hand for me? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Peters, do you want him to repeat this?
I wanted to acknowledge some of the statements he made under oath.
Do you agree that the statements you made were?
I do.
Okay. So you reaffirm all the statements you've made
I
while
do.
you're under oath. Okay.
Good point. Sorry about that.
Those documents, here's copies of the checks. And this is from the county assessor's office showing the ownership of the property and also the land.
Is this document, this document's been altered? Was it altered by the
I
city?
just marked on it, that's.
hearsay.
Okay.
I don't have a copy of the FOIA request or how these documents were obtained. But ordinarily, when you obtain a document from the city and when you seek to admit it, what you do is you get a statement from the FOIA officer indicating that these are documents of the city. That's not present here. These are rank hearsay. They're also relevant.
May I address the board on that issue?
Sure.
I filled out a FOIA document today in the presence of the city treasurer. He's here today.
Do we have a copy of the FOIA request?
Do we have a copy of the FOIA request, Mr. Hart, if he filled it out for you?
I can provide it, I can get it.
I'd like to see it.
Is there a certification?
It was certified by the clerk's office.
We have I don't have a certification here. If there's a certification, I'd also like to see that.
Okay?
It is not typical for us to provide a certification when we release documents.
Yeah, when people ask to
If
admit
they
them,
ask for it.
when people ask to
It's
admit
gotta be
them in
asked,
hearing,
right.
they're certified.
Right.
These are not. So there is no certification, is what you're telling me.
No.
No.
Well, I don't know what the FOIA request is. I find it a little bit surprising that you said you requested these today.
I had discussed it, and I went up and got it
You
today.
discussed it with who?
Well, I discussed it with the city clerk and also with, the city treasurer, and I was able to go ahead and get it from the city treasurer. I filled out the form today.
When did these discussions take place?
Today, when I asked for it, I filled out the FOIA.
Okay, so you talked with the clerk and the treasurer today.
And I asked for.
Mr. Ovian, if you want to sit down, just wave the microphone in front of you, that'd be
Can
great.
we have these
Well,
up
hold
here?
on, let's wait until we make a decision on that.
Yeah, so you asked for the stuff today and you got the response today? Or you called ahead of time and then filed the response later?
No, I called and said I would like to come up today for the purpose of filling out the Freedom of Information Act to obtain the information from the city treasurer.
And you spoke to both Mr. Hart and Mr. Cook?
And Mr. Cook referred me to Mr. Cook. I spoke to his assistant. She referred me to Mr. Hart, who basically handles that.
And you came up and you got you just came up and got the
I
information?
came up, filled out the report, waited, and got the necessary
How long did you have to wait?
information. I don't want to call, sir. I mean, I waited for a period of time.
Well, I've got a FYI request pending right now. I've been waiting 5 months.
Well, that's your situation. I was able to get it today.
Yeah, I know. In fact, that's one of the allegations in my complaint. I
Well,
filed a lawsuit.
you know what?
Okay.
No, that's nitpicking.
Let's, okay, but the point of it is, you're gonna be able to check, you got documentation, you got a copy of the FOIA, we'd like a copy of the FOIA
I
attached
don't
with
have
this.
a copy of the FOIA.
Well, he should have it in the office,
He's got it in the office.
so that's what we need that.
Yeah, I'd like to make a point of clarification. I did not speak directly to Mr. Ovian. However, what I do instruct my staff to do is anytime that somebody fills out a FOIA, the goal is to immediately give that out and if possible, do it on the spot. And so staff acted as instructed. In this case, it's available in that department in which he was at, so it was very easy to do. It wasn't politically motivated. It was simply a well-done job by the staff, just to clarify.
All right. Now, we do have a pending motion to exclude the evidence, and while I do acknowledge that Mr. Peters is correct that it is all hearsay, I will still advise the board that they have wide leeway to accept or exclude the evidence. I would recommend that you accept it into the record, but then when you're determining the weight of the evidence, and I'm sure that Mr. Peters will get into that in his argument, why hearsay should be given little weight, but I would recommend that you allow it at this time and that you determine the weight of it in your decision-making process.
You make a motion, Mr. Seibert, to approve that recommendation by the city attorney? Second that?
And that's a motion to deny?
No, it's a motion to
Accept
allow it
it.
in.
Right.
Yeah, so to.
Right, his
to
motion
deny,
was
yes.
to-
Yeah, the motion.
His request was to deny.
Right, then I'd like to make a motion to deny Mr. Peters' request.
Okay.
So you just want to do it that way, Mr. Pete, you want to second that, Mr. Seibert? Okay, we have a motion and a second to deny Mr. Peters' request and to accept the items from Mr. Ovian as evidence in this case. All in favor of denying the request to deny the evidence signify by saying aye.
Aye.
Chair would vote aye with you.
You mean deny the motion?
Deny the motion, but, so he can proceed, and as soon as we get the request for that, we'd like to have it brought into evidence. Okay? Any other evidence, Mr. Ovian, that you have besides those documents there?
The documents that I have here basically are the ones I just presented here. I do have a copy, of course, of the walking papers that I received in order to go ahead and research my candidacy. And it identifies the named individuals at the residence as being Alex McHugh, Amy McHugh, Andy Moore, and Angela Jo Moore. Is that correct, sir? At 10,503?
You're testifying now.
Yeah.
Well, these were given to me basically by the county clerk's office
Okay, so as a voting record?
as a voting record.
Okay, well, that's,
And-
you can present that also as
All right?
if you'd like to present
And
it.
it shows clearly that Mr. McHugh, Alex McHugh, only voted in the 2014 general election, not prior.
Okay,
Can I see that document? Or is that the one that's attached?
You've got that.
That's the other question, correct?
You've got it in the papers that you were presented when you went ahead and filed
No,
the walking papers.
no, I understand I've received a bunch of documents, I get that part, but I'm saying if you're seeking to admit it here, I'd like to see it.
yeah,
Is that too much?
I agree.
I agree.
Again, rule based on hearsay. There's no certification, as there would be if it's a government document, seeking to admit it, and also in relevance, it shows voted. It shows that he was a resident and voted.
My recommendation is the same. While I agree with Mr. Peters that it is hearsay and hearsay can be unreliable, you can still accept the evidence and judge the weight of it when you make your decision.
Okay.
So if you want to make a motion to accept and agree with Mr. Peters or make a motion to deny, that's up to the board.
I'll make a motion to deny.
Did you second the motion to deny? We have a motion and a second to deny. All in favor?
Aye.
I would vote no on that. So it's 2-1, so deny, so it should be accepted.
Okay. May I give it to the attorney now?
Yeah.
Okay.
We'll take a look and then we'll just pass it out.
Is that the same piece of evidence?
It is. It's everything that he just went through.
Besides just the voter record?
The voter record's right on top.
Okay, what else, all the
The
other
things,
stuff?
stuff he showed you.
The stuff that he received this morning from the city, I
There's
believe.
stuff written on the back of one of those letters, I don't know what that is, and I don't know,
Do you want to ask him about it?
well, no, I'm just saying.
What's the notes on the back? Are they anything to be entered, or that's just your notes?
That's just my notes.
So the stuff on the back of the documents are not to be entered into this?
No.
And that just goes further to my point of why people don't accept hearsay.
I agree.
Because documents are altered, marked, changed. Granted, we can sit and figure out who did what and that kind of thing, but in the court of law, we certify documents that are gonna be admitted. That's what we do.
Brian, may I see that?
Sure. I'll give you all the documents back right now.
I've already lost the motion.
This is just telling me where I need to go to get the documentation with the tax assessor's office. That's
So the board's already accepted.
I'm not saying
the
the
evidence.
alteration is a major alteration, I'm saying it's
There you go.
altered.
Okay.
nitpicking, sir.
Sir, do you have any other evidence? Do you have any other evidence you'd like to submit, or testimony?
No, not at this time.
Okay. Well, we're not going to give you another opportunity to.
Well, the
present
only
evidence or
other,
testimony. But we will give you an opportunity to make an argument at the end. But that's it. So
The only other item that I would like to indicate, and with what I indicated there, that based on his present voting record and based on documentation that I show that where he was a registered voter in Omaha, Nebraska, and I do have copies of that right now, if permitted, but I was going to allow Mr. Subcheck to get into that because he basically filed it with the city. But I was just going to copy on to that he doesn't file, Mr. McHugh does not go ahead and meet the residency requirements. Only because he was not here a full year.
Sir, okay. Do you want to submit that into evidence, or do you just want to continue to testify?
No, I'd like to submit it.
Okay. And once again, I'll ask that you show it to Mr. Peters. You got that one, okay. And you make the same objection?
No, that's not what, you just hinted something that's not what I was told. That's a different
Why don't you
thing.
compare it with, why don't you compare it with Mr. Peters?
Are we not talking about this?
That's this one.
That one we didn't talk
That
about
one
yet.
is the obit.
Are you seeking to admit the obit now too?
I'm seeing.
You want my objections to that?
I assume, yeah, go ahead.
Let's start with the first one. A printout of a screen. We're really at the point where we're gonna accept a printout of a screen of something in Nebraska as proof of something. I'm not even sure what, because it doesn't say when someone voted. It doesn't say a word about, in fact, if you printed out people who've left Illinois, I'm sure it might say the same darn thing in Illinois, even though they've made an address elsewhere. I mean, surely we haven't, I mean, I understand that hearsay is coming in here, which I adamantly disagree with. But to use a printout of a screen and drawing conclusions about someone's voting record from a printout is ridiculous. And I'd move to exclude it. Next, an obit. We're gonna accept an obituary as proof of the facts in the obituary. Double hearsay, essentially. Now, let's think about that for a second. So we have to rely on the Belleville News Democrat to get things accurate. How does everybody feel about?
That was the Vienna Times, sir.
How does Vienna Times? Well, let's use the Belleville News Democrat as an example. How does everybody here feel about the statements they've made and how it's been portrayed in a document printed in a newspaper? Number two, it's not even purporting to be the statement of the proponent. It's a statement of somebody talking about the proponent's mother. What could possibly be the relevance of that? So it's double hearsay, it's doubly unreliable, and it's indicative of the ridiculousness of this petition, this objection. I move to exclude it. Both.
Would you like to respond?
Yes, the obit basically identifies the family members, identifies who are residents of Belleville and who are residents located in another state, namely Omaha, Nebraska, and it specifically identifies Alex McHugh.
Do you want to respond to the allegations that it's hearsay and that we don't know who wrote it?
I think it's basically the hearsay is basically identifiable here. It identifies Mrs. McHugh's background from when she first taught. It's pretty specific. So it should not just be just hearsay. It had to be listed by family members, or otherwise it would not go into the obit.
Okay. Now that's hearsay upon hearsay with speculation. And I know everyone says it says something about residency. The word residency or resident is not mentioned in this document. It's a legal term in Illinois. Residency means something, not what people walk around and think a resident is. There's a specific definition of what a resident is here. Physical presence, intent to make it your permanent abode. I don't say anything about physical presence and intent to make abode in this document, so making conclusions about residency based upon hearsay upon speculation as the writer is wholly improper.
My recommendation to the board is the same.
This three-member panel here, I'm letting Brian do a lot of the moderating, but I would recommend that we would concur with Mr. Peters' objection to these these documents here. I think that we've accepted the other ones because they came from the city of Belleville, and people were in the audience here stating that they accepted them and produced them today. I think these here are, I have to say, you know, accepting obituary as a document is pretty, you know, many years ago, reporters actually called the funeral homes and got the obituaries. That's not even the case. Now they're sent over by wire. It could be any kind of mistakes. There's no proofing there. And as far as that printout on the screen, that does not. So I would make a motion that we would concur with Mr. Peters and strike these two items from evidence.
Second.
So we have a motion and we have a second to concur with the Mr. Peters, the candidate's attorney, to strike these two pieces of evidence. All in favor signify by saying aye. Aye. Mr. Cook?
No.
It's 2-1. Ayes have it, and it would be, that would be stricken.
Okay. Do you have any other evidence you'd like to present?
Other than that, I would just like to present the date of registration as a voter. That is also an exhibit, and it will be further concurred with Mr. Sobchak, that the only time that Mr. McHugh registered to vote was on September the 4th of 2014, had not voted prior to that in any city elections.
Already been asked,
It-
plans are established,
it-
submitted.
Isn't that already one of the documents you submitted, or is this different? I'm sorry.
No, this is a little different. It shows that he was basically, in that document, it wasn't specific. It just said that he voted in the general elections. This specifically says when he registered to vote.
Okay. You want to show that to Mr. Peters?
I'd like to see that also. But this doesn't say anything from even St. Clair County on here.
It says when he registered to vote
But-
in the county.
If you want to say something, make sure you say it to the microphone, just so we get it done.
But where does that say St. Clair County?
September the
Would you have a seat so you use the microphone, sir?
Do you see St. Clair County under Dallas?
No, St. Clair County.
Do you have any, I mean, that, to me, that doesn't show anything that says this gentleman registered to vote at St. Clair County Courthouse, St. Clair County Clerk's Office.
It would be a presumption, however, considering it lists the address at West Main Street in Belleville.
I know, but that could be for anything.
It could be.
I mean,
I
that
mean,
there,
usually,
let me pass
these
that on to
numbers
Mr.
over here
Seibert.
make it pretty clear, but you're right, it does not say St. Clair County.
To me, that document is,
Why don't we go ahead and defer that to to Mr. Holbrook's office to see when he actually voted before you make a decision on that?
If we have someone from the office here to testify, that'd be awesome.
Right, sir, we're here for a hearing today, and you were notified to present evidence
Right.
today.
okay. Okay, is there a motion to?
I can make a motion to recess until someone's available to testify from the county clerk's office. It's a motion.
You made a motion, is there a second to recess?
Well, I will note that the rules of procedure, which the board adopted earlier, said the board shall not grant continuances absent the existence of emergent conditions denying the right to present substantial material evidence. So I would just ask the board to consider that.
There's not been a second on Mr. Cook's request to recess, so that motion would die as without a second. Mr. Peters, did you ask for a motion to deny this? Is that what I understood you to say?
Yes.
So I'd ask if there is a willingness to have a motion to deny this because of lack of proper identification.
I make that motion.
You make the motion, and I will second the motion. We all looked at it. All in favor of agreeing that to deny this particular piece of evidence into the record signify by saying aye.
Aye.
Oppose? Mr. Peters, Mr. Cook, rather? 2-1, okay. It was denied. We move forward.
Okay. Is that the conclusion of your evidence,
Yes.
sir? Okay. Mr. Peters?
I just swear, Mr. McHugh.
Okay.
Okay, sir, can you raise your right hand, please? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I'm gonna speak into the microphone, sir.
Mr. McHugh, can you tell us when you were physically present in the state of Illinois and decided to make it your permanent abode?
March of this year. 10503 West Main has been the only residence, legal or otherwise, that I have maintained since March of 2013. It's been my intent to live there at my mother's request as far back as 2010 when my father was battling cancer. It's been my intent for 4 years. I have had no other residence, legal or otherwise, since March of 13.
Let's talk about that briefly. At one point, you actually owned a home in Omaha, Nebraska, correct?
Yes.
When did you place that home for sale?
think once in 2011, and again, I think in 2012. Wasn't a good time to sell a home.
Did you eventually sell that home?
No.
Did you eventually give up legal title to that home?
Yes.
When was that?
March of 2013.
Since that time, where have you resided?
10503 West Main, and work, took me to Omaha on a business consulting contract for a period of about 9 months
Where'd you live?
with friends.
Did you maintain your permanent abode here in Illinois? during
Yes,
that
I
period
did.
of time? And was it your intent all that during that period of time to continue to reside in Illinois and make it
Yes.
your permanent abode?
Yes.
There's some talk about voting. When's the last time you actually voted in Omaha?
2012 general election.
And you don't dispute the fact that the first time you voted in Illinois was 2014, correct?
No, that's the first time. The first time in 25 years.
There's some talk about ownership of the home. You resided in that home, and I understand there's maybe this view from some people that you have to own a home that you live in. It seems kind of contrary to anything I ever understood about the world, but
Apparently you can pay trash bills. I don't know.
let's assume that's a valid objection. Who owns the home?
Technically, by the strict definition of the law, right now, no one.
It's
My-
in probate.
My mother died intestate without a will, and so the estate is in probate. It is the intention of the siblings. My oldest sister and I are co-administrators on my mom's estate, and it's our intention to have the house put in our name.
No, to be an administrator of an estate, you have to be a resident of Illinois, don't you?
Correct.
And you're administrator of that estate?
Correct.
When did your mom pass?
July 18.
Who was the administrator of your father's estate?
Didn't really have one. He died also without a will. Mom and Dad were old school. They're from the school they tore down to build the old school, and they just everything passed them on. So,
Now, does the probate court decide who pays bills?
no.
Now, someone talked about somebody who was your brother-in-law, Andy Moore. Andy Moore is not your brother-in-law, is he?
No, he's my stepbrother. Mom's first husband died in 1966.
Stepbrother is what I said, sir, not brother.
No, he's
Sir,
brother.
you'll be given an opportunity to ask
I can
questions.
prove that's not the case.
It's neither here nor there. Well, I mean, it matters, but I don't take any offense to it at all.
No.
He's my stepbrother.
And Andy Moore is currently a resident. And it's your intent, he's been a resident for for over the year period you've been a resident, correct?
Yes,
And it's your intent that he'll continue to be a resident with you,
correct.
and you help him.
Correct.
Now, does the federal government know where you live?
Yes.
Seek to admit this document. And I know, unlike any other document received today, it's an original that has the government's name on the document.
Pardon?
Microphone?
Sir,
Unlike
well,
any other document introduced today, this one actually is an original, and it has the government's name on it.
I see where it's dated April the 1st of 2014.
Your opportunity now is to object to that document, I'm seeking to admit it.
Okay, I object to it.
Do you have a basis, sir?
Basis upon when the date of the check was.
Could you elaborate on the legal basis?
Well, if he's saying he basically was a resident all along, then that particular document from the federal government is issued as of April 1st of 2014. Okay? So that alone right there would indicate that if that's when the official date that he received it, was he a resident at that time and only that time? It doesn't show that he was a resident prior to April the 1st of 2014.
Well, sir, what it shows, I mean, doesn't really have to do with the admissibility of it. I mean, do you have an objection just based upon the admissibility or the reliability of this document? You can argue about what the document means when you argue, but just in terms of its admissibility and
It's an
its
admissible document.
Okay.
I don't have a problem.
So you don't have an objection to that?
Not as an admissible document.
Okay, but you can save your argument for later.
Okay.
That's fine.
Mr. McHugh, can you tell me what this admitted document actually shows?
It's a check from the FTC, the Federal Trade Commission, for some sort of shenanigans that my mortgage lender was involved in.
And they sent you a check?
Yeah, for a whopping $13.
And what address did they send the check to?
10503 West Main, Belleville, Illinois.
Seek to admit, letter from, MetLife. You want a foundation for it first?
You want to use the microphone there, Tom?
Does the objector want a foundation for the document before he makes a decision on whether or not he objects to its submission?
Give him a chance to read it.
This document basically just shows that he was paying the mortgage on this loan and listed his address as being 10,503.
Well,
It
right now,
alleges.
we're just asking if you have an objection to the admissibility of it. Once again, you can
I
save your
do.
argument to the conclusion.
do.
Okay, and your objection
My
is?
objection is it alleges that that's where he lived as of 2013.
Okay.
I understand that MetLife basically goes ahead and has provided this document. I'm not going to say that they didn't. I'm just saying it alleges that that's where he lived. He could have paid the mortgage from any place.
Yeah, my issue, my one question is whether you have an objection to the document, not what you think.
Well, I don't object that it's a legal document. However, I do object that I don't know where he was living at when the loan was extracted. If it was paid by direct deposit or basically if he paid it himself.
Okay.
But it is a legal document. I don't have a problem with that.
Move for admission.
We didn't vote on the other.
Before I move into this one, what's the date on the letter from the federal government?
April 1st of 2014.
And then both documents.
Okay, so do I hear a motion to accept these two documents on behalf of Mr. McHugh? Motion by Alderman Seibert. Second by Mr. Cook. All in favor signify by saying aye.
Aye.
Chair votes aye. We accept those documents.
And now tell us what the second document is, sir.
That's a statement of my escrow account on my previous residence in Omaha for the period of 2012 ending March of 2013.
So when MetLife was looking for you, where'd they write to you?
10503 West Main Street
And you had the envelope with it too?
with a United States postal mark, yes.
Also, I don't know if I'm important. These are medical bills, so they're very sensitive. If they're gonna be admitted, I'd admit them under seal. I don't particularly wanna even show them to the, well, let's do it this way. Sir, can you identify the three envelopes I have in front, that you have in front of you? What are those documents?
They're medical bills from hospitalization at the end of 2012.
And actually, part of that, the treatment concern when you're actually out in Omaha, correct?
Yeah, it's also one of the reasons that I voted in the general there, because I was hospitalized in Omaha at that time.
When they sent you, when these hospitals sent you bills for payment, where did they send them to?
10503 West Main Street.
Then I would seek or acknowledgement that these letters are in fact as they've been testified to, but again, unless they're gonna accept them under seal, I don't think you would want them because your requirements under FOIA,
Right.
under HIPAA are
Yeah.
very, very sensitive.
Right.
So I move that the documents be admitted and that they be withdrawn. You can peruse them at the outset if you
Yeah.
like.
Just to see the date.
Yeah.
It's 13. I'll make that motion.
We have a motion, do you hear a second, Mr. Seibert? We have a motion by Mr. Cook, second by Alderman Seibert. All in favor of the motion to accept these documents with those conditions as explained, signify by saying aye. Aye. Chair also votes aye.
Now, sir, there's some talk about a document being April 1st, 2014, proving that you weren't a resident 1 year before the general election. Do you know when the election coming up? Do you know when that election is?
April 7th, 2015.
Is April 1st within a year of that?
It is
An excess.
in excess, yeah.
That's all I have. Probably approved.
Okay, Mr.
Mr. Ovian, at this time, you know, there's no more evidence to present, but you can simply just make an argument to the board.
Okay. Just in regards to the documentations that have
So all
been-
the evidence which has been presented, whether you presented it or Mr. Peters presented it, you can make an argument to everything. This is your final word.
The documentations that he's presented, you know, I know how documents can go ahead and basically be identified. Mailing addresses are always achievable. You can send it to wherever you want, regardless of where you're domiciled. Now, if he basically was a registered voter in the state of Nebraska, in Omaha, and if he did not go ahead and register to vote here, then how can evidence be proven that he didn't have registration both places? I submitted documentation to show that he was a registered voter in Omaha, Nebraska. Secondly, and this probably will not be accepted, but I'm a little disappointed tonight, only because I feel as though that one party here should have recused himself from basically voting on the admissibility of the information that's been presented tonight. And only because there's close family ties. And I feel that there is an injustice here, and I think that basically it's, if it does go forward and Mr. McHugh is basically left on the ballot, so be it. However, I do object sincerely because Mark, you've been a close family friend of the McHughes, especially Mary McHugh. She was your teacher, your mentor, your supporter. Okay?
Well, I'll respond. I mean, if you wanted to make a motion to disqualify the mayor from the board, I mean, the time to do that would have been the beginning when we
It
asked for
should have been,
motions.
and
So asking for it at the conclusion of the hearing is inappropriate and it's not timely. So,
Okay. I should have said it
sure.
out here in the public.
You even could have filed
information.
something ahead of time. I mean, knowing
should have
who was going to be on the board. I mean, you had ample time, sir.
Right.
So,
And that's my fault. Being green is no excuse.
okay. Do you have any other arguments to make?
No,
Okay.
not at all.
Mr. Peters.
All right, responding to the arguments that have been made, let me just start with this. And I know that it's been ruled on. If a motion for recusal was that you cared, loved, and respected Mary McHugh, I don't think there's very many people who could ever sit in judgment here. That's one of the reasons, or the main reason I'm here, because I don't think she'd like it very much if I wasn't. And all she wanted was people to participate. And so arguing somebody should be removed because they loved, respected, honored, and cared about Mary McHugh, to me would require the recusal of basically everybody in Belleville who had sense enough to know her. Number two, close ties to somebody's mother. If the claim is that a person lived in Nebraska during, and wasn't a resident of Belleville, I don't know how you can argue a close tie to somebody in Nebraska if someone lives in Belleville. I think that's convoluted logic. Finally, the only argument registered at closing, based on the evidence, which I think most of it should have been excluded, all of it in fact, is that a person was registered in Omaha. First of all, that proof wasn't accepted. That evidence was excluded. But there was testimony, completely forthright testimony, where Mr. McHugh indicated he voted in 2012 in Nebraska, and that's the last time he voted in Nebraska, that he had 2 family members with cancer, moved back here and voted here in 2014. Under the statute, all that's required, and that's all, the only requirement is this physical presence in the state and an intention to make that domicile, that place your permanent abode. He's testified clearly to it, and we have the indicia that not only did he believe and want it to be his, and it was his, that be his permanent abode, but so did the federal government, so did people who were looking for payment for their bills, and so were the hospitals who were looking for issues concerning the street. In fact, there's no evidence that he even had a domicile or a place to live in Nebraska after within a year of this upcoming election. And if you look, when Mr. Ovian was talking about the FTC document, how he indicated April 1st, not being the proper time period, it's precisely the proper time period. And it shows why we should have dismissed the petition to start with.
May I respond to that?
No.
No, sir.
Okay. I would just like one thing
No,
noted.
sir, you were
I
given rules,
understand,
you were
but-
given rules of procedure.
I understand.
And I asked you multiple times, do you have anything else to say, and you said no.
I understand.
So, just to be fair to everybody, we're gonna do the same thing to everybody tonight. We're gonna
I
follow
just
the
want
rules.
it noted that I had no character assassination against Mary McHugh.
Okay.
She has nothing but an irrefutable reputation, even while she was alive. I will give you that, sir. She was a wonderful lady.
Okay.
All right?
A motion is in order for the board.
Okay, so, but at this time, you had said we were gonna hear the other evidence before we, about the next case, we could just,
Oh, no, I think you can go ahead.
We can go ahead.
Decide this one.
okay. So, under deliberations, based on hearing the objections that were presented by Mr. Ovian and the answers to those objections by Mr. McHugh and his attorney, Mr. Peters, what is the committee's, the group's pleasure? To deny,
It would be so you're saying you want to deny Mr. Ovian's objection?
deny. Speak into the microphone so he can pick it up.
Yeah, I would make a motion that we deny Mr. Ovian's objection.
Mr. Cook? I will second that. I will second.
Like input, or would you just like?
Yeah, no, we'll certainly open it up now. So
Now it's
we have a motion and a second to deny.
Okay.
Any comments?
My thoughts are that when people go out and do the work to get on the ballot, I'd like to see them on the ballot. I'd like to see the people decide. And there's no question about that. And if Mr. McHugh is here and he is saying that he lived at that address for more than 1 year and that he is qualified to run for that office, it's hard to do anything other than to take a gentleman's word. And for that, I will be concurring and denying the motion to remove Mr. McHugh from the ballot.
So formal roll call, Mr. Seibert,
Aye.
and I also vote aye to deny.
Okay.
Okay.
I'll have a formal decision prepared and executed, and I'll have one mailed to each of the parties. I think
Thank you.
a motion to adjourn.
Motion
case
to adjourn
15
case
1.
15-1. So moved. Do I hear a second? Second. Motion and a second to dismiss or to adjourn case 15-1. Signify, all in favor signify by saying aye. Aye. Also aye. Motion carries. First case dismissed. I would immediately go to open the second case, case number 15-2, Jan G. Subject, petitioner objector versus Alex J. McHugh.
Okay. Let's go ahead and take a roll call now.
Yeah, we'll go right on into roll call. Mr. Seibert is here, Mr. Cook, I'm myself, Mark Eckert is present. Mr. Flynn is sitting in, Assistant City Attorney, and we have our court reporter. Mr. McHugh is here, and also we now have Jan's, is it subject, sir? Subject, and you are an objector to this this evening in case 15-2.
Correct.
Ready to go?
We do public participation.
Public participation. Is there any public participation now? Hearing none, we will close public participation. Yes. Sure.
Absolutely.
We'll take a brief pause for the court reporter. And if anybody else needs to take a break for the restroom, we'll do that. Seibert, this is the first one we decided on. Right down there. You ready? Okay. Mr. Peters, is that okay with that stuff? Okay. Set that back up here, if we can. This is the first one signed. Thank you very much, sir. Okay, ladies and gentlemen, we are back in the second hearing, case 15-2. Jan Subcheck, the objector, over Alex McHugh's candidacy for Alderman in Ward 4. While we were on break, there was a conversation, and I would ask at this time, Mr. Subcheck, do you agree to accept all the previous testimony that was given in the prior hearing? So it doesn't have to be each item, just go into new stuff?
Yes, that's fine.
Testimony and documentary.
Testimony and documentary.
Yes, that's
That
fine.
was, okay.
And if you'd like, I mean, if you want the opportunity to question the witness, since you weren't given the opportunity previously, you can question Mr. McHugh if you'd like.
Okay.
But we can get to that.
So, with that being said and that being agreed upon, we will allow Mr. Subcheck to go ahead and present any other additional documentation he would have or case.
Okay. My name's Jan Sobchak, and this is my wife, Monica. We've been at 11 North 50th for 25 years, and we're just objecting to his residency. Most of it, some of this stuff's been thrown out already. The only thing I have is his Facebook page. As of the 29th of December, still says he lives in Nebraska. His obit says he's in Nebraska. Come on, from 2013. If you move to Belleville, you're going to change those things. And you do need an occupancy permit if you have your water or your electric changed, and that's a law. And so, I mean, somebody there had to have had that changed over when their parents passed away. So, and when they do that, everybody there has to be on the occupancy permit. And that's a rule, that's the law. And all I'm asking is that you follow the law.
Okay. Mr. Peters,
In response to those issues, first of all,
use the microphone, okay, so we can pick you up.
first thing, are we admitting a Facebook page or are we accepting the hearsay?
Yeah, I was going to ask the same thing. Do you have any specific documents that you would like to submit?
It's in the paper that's.
It was included with
It
the
was
objection.
included with the objection I
so
set.
we should probably go ahead and take notice like we did the last hearing, Mr. Mayor.
That's Exhibit D to the petition.
So Exhibit D,
Give a copy. Yeah.
okay. Okay, let me back up just one second. As we did all the other things, I guess we officially ought to be on record as adopting this is a separate case, even though we've been through one, adopting the rules of procedures. We've been through it, but do I hear a motion to adopt the rules of procedure for this case 15-2? Motion by Mr. Cook, second by Mr. Seibert. All in favor of adopting the rules of procedure signify by saying aye. I also agree. Motion carries. We've already talked about the preliminary matters of the motion. We need to also take notice of nomination papers and objections. So that's what we're really into right now. And in your objection, Mr. Subject, you meant in your objection here, you mentioned your items basically are stated in here. You want to go over them a little more detail so we got your objections on record? The very first part of your page.
Well, the first one was the obit. That it was stated that he still lives in Nebraska, and this was in July of 2004.
And from the previous thing, we did omit we did strike the obituary.
Right.
So you
So
agree
the
with
only
that?
other thing I have is this Facebook page.
Okay, so that's the other item of thing.
And then the
And
water.
it's in here, it's the items in here in the back of your original, your objection.
Right.
Okay, so can you explain a little bit more about this Facebook page though? Because my copy is very poor.
Well, in there it shows that this was as of December 29, 2014, that he studied at University of Nebraska, and he lives in Omaha, Nebraska, but he's from Belleville, Illinois. And then on December 25th, he changed his profile picture, but he did not change his address or anything else. And I think after 2 years, if he supposedly lived here since 2013, he would change that eventually.
Can I ask some questions on a foundational basis?
Sure.
Can you tell me where you got this?
Off his Facebook page.
Is this page, is the page private?
Apparently not.
I mean, no.
I'm sorry. Are you both gonna testify?
We didn't swear him in.
Right,
So,
I mean,
I'm sorry.
so I guess that's my question is, one, we need to swear you
You
guys
got
in,
it.
and I wanna know,
Quicker.
we gotta question one of you at a time,
Okay.
if he wants to question you.
So I think we could swear them both in. If we want to both stand and be sworn in, and understand also that what you might want to, you want to swear them in first?
You gotta raise your right hands, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
And subjects, do you agree that what you've said already is, you understood that was under oath?
Oh, yes.
Yes.
You're
Yes.
certainly
Yes.
understand that what
Oh.
you've said so far in this hearing?
Correct.
You're not changing anything?
No.
Nope.
Okay. So, thank you.
Okay.
Been a long day already. Mr. Peters, with that being said, you know, they're sworn in, I'm sorry.
How long was this Facebook page pending? You know when it first started?
No, I couldn't tell you that.
It says on there.
Its first date, what's the first date of it? 2008?
I have no idea.
Now, my daughter maintains my Facebook page for me. Do you know?
That's fine. We're not dealing with your daughter, sir.
Okay, well, great, and I'm glad you acknowledged that. That's a very important acknowledgement. Who maintains this page, sir?
That I do not know, sir.
On that basis, I would move to exclude the document.
If I may.
No one knows who maintains it. It's a copy. It's not the best evidence.
If I
And
may.
it's
No,
hearsay.
no, you're not the objector. So I mean, either the objector can make a statement, or that's it.
Okay. If you're running for alderman, you want the perception to be that you are a Belleville resident, right? Makes sense.
Well, if you're running for alderman, you should have the perception that you're a Belleville resident. And so far, sir, I have not seen any proof. And the burden, it shouldn't be on me, it should be on you to prove that you live in Belleville. And a mailing address doesn't necessarily make it your legal residence. Just because you get mailed there and bills sent there, it doesn't make it legal, sir.
So on that basis, given the complete misunderstanding of the burden of proof, I would ask the document be excluded. It's not my burden, it's their burden. Yeah.
Yeah, just to clarify, it is the objector's burden to prove whatever he's objecting to,
Okay,
so.
okay.
So.
Mr. Peters, you're asking that this be stricken?
I asked the document's rank hearsay. There's no testimony as to who maintains it. There's no testimony that the information on it's accurate. There's no testimony that's kept in the ordinary course of business. There's no testimony concerning any of the exceptions to the hearsay rule. Not only is it hearsay, it's also a copy you can barely read. So the best evidence rule actually well, every best evidence rule applies to most of the things that happened here. It's clearly apparent here, you can't even see the pictures. And on that basis, it's unreliable, and it's hearsay, and it should be excluded.
Well, who does maintain it then?
Ask him directly.
Can I ask that question?
Not at this time, you're presenting evidence.
Okay.
Okay, so Mr. Peters has asked for a request to strike this evidence. Before we go any further, I'd ask that you would swear in Mr. McHugh, so in case he chooses to comment here, we got that accomplished.
Can you raise your right hand, please? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Do you have any other comments about any of this before we would take a vote?
No, you're not.
The last several
We're
months.
talking about on the evidence issue.
Yeah, on the evidence.
No, I don't have any, he has no testimony on the evidence issue.
Okay. Okay, so we have a request by Mr. McHugh's attorney to strike the Facebook evidence. Keep in mind that we did agree that the obituary and the other document coming from a copy of off the web or something from Omaha was not acceptable. So I would ask for a motion to concur with Mr. Peters' request and strike the evidence that was presented. Mr. Seibert makes the motion. I will second the motion, and I will open it for discussion. Mr. Cook, you have any discussion?
I'll just vote no.
Okay, so I will call for a vote. Let's have a roll call vote. Mr. Seibert? Dallas?
No.
And I vote aye. So that Facebook account, which is, I think, not knowing who, I have a Facebook account too, and I don't manage it. So I can certainly agree to the same thing. So that motion was denied. So we go on to, if there's Mr. Subject, do you have any other?
I don't object to, I'm happy to say I don't object to Exhibit E. I think you take judicial notice of it.
Exhibit A in his packet? E?
The law.
The law. So Exhibit E, do we officially have to accept that? It's the law. I don't think we have to. Okay.
I thought he moved to admit it, I'm sorry.
I mean, but you, okay, you did submit, okay.
Do you have any other evidence you'd like to submit?
No.
Yes.
Go ahead, then. You have to.
Ask, tell him that you want me to speak on your behalf.
Can I have my wife speak on my behalf?
No, unless she's a licensed attorney.
No. Okay, no, I'm fine, thank you.
You do need to just avoid speculation.
Okay, Mr. Peters, do you have any other comments before we get to the closing arguments?
Yeah, I have questions of the witness concerning the one issue that did come up, and that's occupancy.
Okay, it's for questions for Mr. McHugh?
Sir, you understand you're still on the road, correct? As far as the occupancy permit is concerned, did you get an occupancy permit?
No, I did not.
I understand that you had a father and a mother undergoing cancer treatment and serious health issues that ultimately neither turned out very well for you over that period of time. But given that, can you tell us why you didn't apply for an occupancy permit?
You know, we're from the country, we're from Southern Illinois. It didn't occur to me in my wildest dreams that you needed to obtain an occupancy permit to care for a terminally ill parent.
Now that you know that's the law and that you're an occupant there, are you gonna go get one?
Sure.
That's all I have.
And one question I have for Mr. McHugh, did you grow up in that house?
Yes.
So, and how many years have the McHughes lived in that house?
58.
So that would have been before the city had occupancy code, way before. So your mother and father wouldn't have been required, and you were a sibling growing up in that house. How many years were you in that house, Alex?
18.
Okay.
That's not the issue.
I understand, I'm just trying to clarify.
No, I agree. In fact, I'll say, you're gonna get one, aren't you?
Of course.
Okay, good.
It's
I'm
important to be
gonna
legal.
remind you that you're not the objector and you're not an attorney. So unless you're called as a witness, I'm gonna ask you not to speak. Thank you.
Nothing further.
Okay, you have a final rebuttal or final argument, Mr. Subject?
Can I call my wife as a witness?
Yep,
That's fine.
okay.
First of all,
Before we do this, just so you know, the evidence issue is closed. I put on my evidence in response to their evidence. The witness is limited to rebuttal,
Right.
right,
just so we're clear.
okay? And you have been sworn in, you understand you're under oath?
Yes,
Okay, so you have a chance to rebuttal on behalf at the request here, as a witness.
as a witness, I would like to bring up the point that it's never been stated again exactly when he moved to that address. And another thing that would,
At this point, I object. This is argument. This is not.
I'm not arguing, I'm
If you're
stating a
talking-
fact.
If you're stating what someone else said, that's argument.
No, I'm
You
stating
have-
what Mr.
I'm
McHugh
gonna
said.
interject, and I'm gonna ask that you not testify unless you have questions that you're responding to.
Okay, ask me. Okay,
Or fact.
you ask me.
All I'm asking is that the laws be followed. So far, there's been no proof that it's all been mailing addresses. He's given us no physical proof that he's lived there for 2 years.
The burden is on you as the objector. If you have questions for your wife, you can ask them at this time.
No, I'm done. I'm done. Thank
You
you.
finished?
Just
Okay.
ask him. You have that
Okay.
burden
Okay.
of proof.
It's a joke.
The
It's
objector
not
said he's
legal.
finished. Sir, if you would like to make an argument at this time, you can go ahead.
No, I'm done. Thank you.
Okay.
Okay.
Mr. Peters?
Mr. Peters?
Based on the previous hearing, this is, nothing new has been added other than the fact that Mr. McHugh neglected to get an occupancy permit. He's going to get one. Testimony is quite clear. He didn't understand that he needed to get one. It's also quite clear that he knows he's wrong. He's gonna fix that problem. But as far as residency is concerned, the thing that we're here for today, the testimony is clear that he was physically present and had the intent to make the address in the fourth ward his permanent abode by at least, at the latest, March of 2013. He has the indicia of his address there from how people communicate with him. I don't know how anybody else could actually prove that he's there, and he indicates he lives there. So I have nothing
And there's
further
been
to
no
add.
witnesses today that have any proof that he's not been there at that address.
His driver's license should show that he lives there. That's simple. That's,
Okay,
have him
ma'am,
produce that.
ma'am,
The
once
burden
ag-
of proof is on
ma'am,
him.
once again, you're not a party to this proceeding.
Yeah, but just to stop the ridiculousness,
Yeah.
I don't know why we just can't have an election.
A fair one.
I agree.
That don't happen
Submit
around
it as
here.
evidence, please.
Maybe you see it, but
Help a little bit, yep. I don't know why it wasn't brought up to begin with.
because it's ridiculous.
Issued September 4th, 2014,
What's the address?
10503 West Main. You have to change your driver's license 30 days. September 4th, 2014
So
is the
it's-
date of it issued.
So when you said you wanted to see the driver's license, you meant you wanted to see more.
No, it should be submitted as evidence.
We're not gonna submit, Your Honor.
Well, I wouldn't think so, because it shows that he wasn't a resident.
First of all, is there any decorum in this proceeding whatsoever, or are people from the peanut gallery gonna be barking off as we go through?
I'm
assume-
done.
The objector's already stated that he's finished. I assume Mr. Peters is finished, so I believe a motion is in order.
Okay, Mr. Subject is asked to object to the petition. I'd ask if there's a motion to deny his, similar to the other one. Motion by Mr. Seibert. Dallas?
You're looking for a second.
I'll second the motion.
I've got it.
Do you want to make another statement? Same as before, just kind of.
Yeah, I have a question, if that's okay,
I mean,
that has been raised during this hearing that I didn't get before, that I'd just like to clarify.
well, you go straight, I mean, all the evidence is closed. I mean, like, we can't really get.
Okay, so we cannot ask any
They're not
questions?
They're not obligated to answer. You know what I mean? Just, the evidence is closed.
Okay. Well, then I'll just make my statement. Mr. McHugh said that he didn't in his wildest dreams believe you need an occupancy permit to come home to take care of one of your elderly parents, and I couldn't agree more. However, when you say that, it shows me the intent was to come home to take care of them, not necessarily make that a permanent abode. Wherein Illinois law it is correct that Illinois law does require you within 30 days of moving into the state to go to the DMV and obtain a driver's license. It doesn't seem like you did that, or you did do that and the date is in conflict of the one that I was understanding before. The driver's license is very helpful, and I would have liked to have seen in the beginning we made this very easy. However, all that it does for me is show that you got it in September of 2014, therefore leading me only to believe that if you were following law, that you did not move here until early September. And with you not being able to answer that for me, it makes it more difficult. Because like you said, you're coming home to take care of an elderly parent. Why would you need an occupancy permit? You don't. But if you intend to stay, and you intend to put the utilities in your name, and you go through all that process, then things will happen that make you forced to go get an occupancy permit. For example, when I move into my home, I put the bills in my name or whoever's name, and then you have to do something. And it's not even the city that triggers that. The utilities won't be turned on if you don't do it. So what I see here is you left it in their name, and therefore it didn't trigger it, so why would you get an occupancy permit once again? If you're not forced to do something, I don't know anybody who goes above and beyond to appease the law. So it just leaves me with that daunting question of, were you not aware of Illinois state law, or did you not follow state law and just happen to have got the license at that time? Or is that really the time, you decided you want to get your affairs in order, and you did things like, your mailing address and and everything else. That's the only thing that's changed a little bit for me, and because intent, that is, Mr. Peters is correct. The question here is what did you intend to be your permanent residence 1 year prior to this election. If you intended it to continue to be Omaha and then things happened and now it's here, that changes this, and it makes it hard to determine whether or not you meet the residency requirement. But however, once again, it was not put into evidence, your driver's license. So therefore, am I to not accept the fact that I've seen his driver's license? Should I pretend like I have not seen that?
Well, you need,
It's a tough one.
no, well, you need to keep in mind that the burden of proof is on the objector. So looking at the evidence that the objector has presented, you can make your decision based upon that.
Okay.
So I mean, it's their burden of proof. So, I mean, did they prove it or did they not prove it? So.
Okay. Okay. We can proceed with the
So
vote as
we
far
have a
as
motion and a second to deny the objection. And remember, the second objection here is primarily the evidence of the Facebook page, because we had the first, other evidence was denied earlier in the previous hearing. So at this time, I'm calling for, if there's no other comments, no other additions to be added, I'm asking that we have a vote on this to deny Mr. Subcheck's request of objecting to his, Mr. McHugh's running for office being placed in him. So we already got the motion, I already seconded it, so we're gonna have a roll call.
Aye.
And the chair also votes aye. So the objection is denied, and I'd ask for a motion to adjourn this hearing. Case 15-2. Motion by Alderman Seibert, and do I hear a second?
Second.
Second to adjourn. All in favor of adjournment signify by saying aye. Opposed? Motion carries. This hearing's done. Well, we'll have a brief shift in people here, and I will call this third hearing to order. If you're here for case 15-3 of the City of Belleville Municipal Officers Electoral Board, you're in the right place. This particular one is being, the request is Mr. Lester Byrd, petitioner, objector versus Paul Seibert, candidate and respondent of Ward 6. I see that Mr. Sprague is here representing Mr. Seibert. And at this time, I will, if they could take the conversations a little bit to the right there, that'll be helpful. Dean, if they could go a little bit down. Please use the microphones when you speak so that this is being recorded. At this time, I'd open public comment. Is anybody from the public? Let's do roll call. I'm sorry, I'm getting ahead of myself. We have present Jim Musgrove, the second senior alderman from Ward 8, myself, Mayor Eckert, and Dallas Cook. Brian Flynn is sitting in for Garrett Harner as our assistant city attorney, and the other gentleman on the top front here is our court reporter, John. Mr. Seibert's present, his attorney, Mr. Sprague, and Mr. Byrd is present. Everyone's been identified. At this time, I'd ask also, as the previous, that we'd have a motion from one of the committee members to adopt the rules of procedure.
I'll make that motion.
Motion by Mr. Cook. Do I hear a second?
Second.
Second by Mr. Musgrove. All in favor of accepting the rules of procedure signify by saying aye.
Aye.
Opposed? Motion carries. I take it you two gentlemen did see the rules of procedure, right? You get copies of them?
Yeah, I got copies of it.
You got a copy? I assume it was served upon you.
It should have been served upon.
Served upon me?
Yeah,
No.
when you got your Friday day,
You want
No, I didn't get those.
you want to come get a
to
copy
take a
of it?
look?
This should have been, you should have received this with the notice
Yeah,
of the hearing.
You got a notice to the hearing, right? That would have been part of that.
Okay?
Do you have a copy? You can keep that, I mean, if you want. Okay. If there's any preliminary motions.
Okay, any preliminary motions?
Yes.
I have none.
I have some. I'd just like to ask a couple questions of Mayor Mark Eckert. The last time you ran for mayor, what party affiliate?
I would object to him,
This
examining a
is
member of the board.
I agree,
That's
Mr. Byrd,
procedure.
you don't have the ability to question members of the board. If you have a motion to make, you can go ahead and make it and state your argument, if you'd like.
You said, well, now I don't have a.
If you have a motion to make, And if you want to make an argument in regards to that motion, you can go ahead, but you don't have the ability to question the board members.
Okay, well, I see up there 2 individuals that ran for office in the last city election that was part of the Good Government Party. And that would make it biased, make them biased to Paul Seibert, who last ran up under the same auspices of the Good Government Party when it existed.
Okay, so I assume you're making some sort of motion to disqualify the mayor?
Yes,
Okay.
they should be disqualified.
Can I respond?
You may respond.
First of all, my client's running as an independent candidate,
This year,
not as a member of a party.
this year.
I'd also like to cite the case of Ryan versus Landick to the board, 512 Northeastern 2nd First. And where it says due process did not require that 2 or 3 village electoral board members recuse themselves from hearing objectors' position to political parties' nomination paper, although they were officers of the parties at the time of the hearing. These people don't have to recuse themselves, and my client's not running with the party, he's running as an independent.
I agree. My review of the law shows that there's nothing here that, based upon that motion, to disqualify the mayor or Mr. Musgrove. So I would recommend to the board.
So I'd just like to put that in the record. That's all
No.
I like to do, make sure that people know that there's 2 voters up there who was gonna make this decision tonight
Okay.
that should be disqualified.
And it has been noted, and I will recommend to the board that that motion be denied.
So we need, somebody has to make the motion? though?
Right.
Is there willing to make the motion to, from Mr. Byrd's motion to have myself and Mr. Musgrove taken off the committee for this purpose? Is there someone willing to make that motion?
I'll make the motion to deny.
How can you deny his own self?
We can keep going.
We have a motion and a second to deny Mr. Byrd's request to remove 2 of the board members. All in favor of denying that motion, his request, signify by saying aye.
Aye.
I also vote aye. Move forward, please.
Okay. Mr. Byrd, at this time, you can present any evidence that which you have.
All right. I'd like to ask Mr. Seibert some questions.
First of all, let's do this. Let's swear Mr. Byrd and Mr. Seibert before we go any further.
Can you both raise your right hands for me, please? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Okay. Okay, Mr. Byrd, for beginning here, I'd like to ask you specifically to read your objection, exactly what it is you're objecting to tonight.
Well, there are several points I'm objecting to. I'm objecting to Mr. Seibert was not the circulator of some of his petitions. That's one. Number 2, Mr. Paul Seibert did not sign his petitions. That's 2. Number 3 is that Mr. Seibert failed to fill out his petition papers correctly. That's number 3. Mr. Seibert did not put his petition papers in the corrective order that they should have been in. That's 4.
Okay, those are the four objections you have.
Yes.
That's been filed, it's been read. Okay, so begin with your evidence of proving that.
Approving that. I want to ask Mr. Seibert some questions. I can ask him questions. It's my time to talk right now. Mr. Seibert, where do you reside at?
Where?
Yes.
Use the microphone, please, Paul.
From St. Clair County Highway Department.
How long have you been an alderman for the city of Belleville?
37 years.
Okay. Did you, for 37 years, and
When Mayor Brown got elected.
have you ever been part of the Good Government Party?
Have I ever been part?
Yes.
Yes.
When was the last time you ran?
Object, it's not relevant.
The last time you ran for, you
hold
can't.
on.
Question, it's not relevant what party you ran with last time as to these petitions.
When he makes an objection, please allow him to speak.
Okay.
All right. So we do have an objection on the table. Would you like to respond to his objection?
Yes, I would like to expand because I'm making a point. I'm gonna make a valid point as to why I'm asking him these questions.
Well, right now, I mean, why is what party he used to be a member of, why is that
Because
relevant
I'm
to your
tying
petition?
both of them in together. I've already objected to those two up on the board right now, sitting up there and not being able to make a qualified decision
Okay.
about whether or not he should remain on the ballot. And also, I'm tying him into the same reason as to why he is a member of that good government party.
Okay, but okay, but if that doesn't tie into your objection papers, it's not relevant, as Mr. Sprague
Oh,
said.
it's relevance because they cannot make a good decision about this man, about whether or not he should serve the citizens of Belleville. And also, I'm gonna show also the fact that Mr. Seibert, he's been an alderman for 37 years and just got through sitting in Mr. Musgrove's seat, but, and making decisions about other people, whether or not they should be thrown off the ballot, but he can't even fill out his own petition papers correctly. Now, how can that be?
Okay,
This is all irrelevant.
No, it's not.
Already ruled on it.
No, we haven't ruled on it. No, there's been no ruling on this at all.
okay. I mean, based upon his argument, I mean, I would recommend to the board that the board accept Mr. Sprague's motion. I mean,
So I'd make a motion that we concur with Mr. Sprague's motion to object to these,
Now, the board does have a little, you know, if you want to grant a little bit of leeway, just to see where it's going, but, you know, just.
Second?
I'd ask if there is a second.
Second.
Discussion on the objection. All in favor of the objection signify by saying aye.
Aye.
Aye. Mr. Cook?
No.
Okay, the ayes have it. Proceed with your original motion, your original objection about the specific questions.
Well, I want Mr. Seibert to acknowledge where he lived. I second want Mr. Seibert to acknowledge how long he's been an alderman. And his attorney said today that he's running as an independent and not good government party.
He is.
I know that. So I'm trying to say that Mr. Seibert, as an independent now, that's what he's running as, he should have the knowledge of how to complete his own petition papers out. His petition papers was not correctly filled out.
Well, sir, you can ask him questions about how his papers were filled out. I mean, you can talk about that. You simply, the board has simply ruled that what party he used to be a member of simply isn't relevant to this proceeding. But you can ask about the nominating papers themselves. You can proceed.
Okay, Mr. Seibert, did you walk and talk to each individual that you signed on the?
I signed on my petition.
Let me finish my question.
Finish.
Okay. Did you walk and talk to each individual that signed your petition papers?
Yeah, that I signed.
No, that
Yeah.
you signed.
Yes.
Okay. And what about the papers that other people walked and talked?
What about it?
Did you sign them?
Did I sign them?
Yeah.
Not as a circulator.
Not as a circulator? What
No.
did you sign them as?
At the top where it says.
I don't know what it says.
Well, let me tell
He
you.
already testified that he.
We're not, it's not your time to talk.
Hold it.
It's not
He's
his time to
he's
talk.
he is his legal counsel, and you ask him a question.
He asked him a question if he.
But he's
Mr.
explaining
Byrd,
something.
Mr. Byrd, you asked Mr. Seibert a question. You could have brought legal counsel with you. You had that right.
I don't need
Okay,
legal
but
counsel.
Mr. Sprague came with Mr. Seibert. He has a right to answer. Mr. Sprague, proceed.
Mr. Seibert's already testified that the people that signed the petitions on which he signed as the circulators, he talked to and they signed in front of him.
That's my first time asking him that question. So when did he answer that? Let's go back in the record. When did he answer? He never said that. He never answered that question. This is my first time asking him that question.
That you started asking about petitions circulating.
Yes, this is my first time asking about it.
Well, you just started. Moments
Well,
ago.
I'm saying he's saying that Mr. Seibert already answered the
Why-
question. He
why-
haven't answered
sir,
anything.
why don't you go ahead and clarify your question?
Okay. I asked Mr. Seibert. I asked him again. Mr. Seibert, did you sign the petition papers that were circulated by other people?
Did I sign them?
Yes.
Don't look like it.
Don't look like it. Well, who signed them, Mr. Seibert?
I signed mine,
You signed yours, but who signed the other ones?
the person who circulated them.
Who circulated them?
Uh-huh.
Okay, all right. That's all you had to say. Now, what pages did you sign? You know?
Oh, I have to look. Can I look?
Yes.
Regulator. Page 2. Page 5.
Okay. Now, are you the person that submitted the petitions to the county clerk?
Not the county clerk.
I mean, the city
City.
clerk, city clerk.
Page
You did, right?
Yes.
Okay, now, the other question is that on pages, here's pages, you said you only signed pages 2 and 5, right?
I believe that's correct.
Is that, no, you believe it's correct, is it correct?
I believe it's correct.
He answered your question.
I need to know if it's correct or not.
That's the answer you got.
Tell us where you're going with this, Mr. Byrd.
I am. I'll have to tell you right now. These are petitions, pages 1, 3, and 4.
Can you show that to Mr. Sprague first, please?
Those are pages 1, 3, and 4. I want to turn your attention to the part that says, I, Mark Kern, 111 South High Street, in the city circle, the circle of Belleville. Am I correct? Right?
Document speaks for itself.
Okay. All right, so then I want to turn your attention to you said page 2 and 5, right? That is for each of the following pages I just gave you. Pages 1, 3, and 5, 1, 3, and 4. They're all circled, right? Am I correct? And it tells you that you must circle it. Correct?
We would stipulate that 1 and 3, city is circled, page 4, it's not circled.
Yes, right. 1 and 3 is circled. That's another one, you're right. This is the site pages where he did not circle.
We would stipulate that on page 2 and 5, the city is not circled, the word city.
And that is a violation of, tell you what violation is of. Illinois.
You know, I think this is an examination, and you're supposed to be asking questions instead of making statements.
No, it's Illinois statute, hold on for a second.
Well, sir, I mean,
ILCS,
sir, I'm just gonna tell you, if you want to make arguments, you can do it at the end. But just right now, just for kind of a procedure type situation, if you want to ask him questions right now, you can ask questions. But at the end, if you want to make an argument, you can make an argument. Okay.
all right, I'm just trying to, he said where I was going with this.
No, I'm just letting you, help you be orderly. So if you want to ask questions, present evidence, now's the time. Argument will be at the end.
Okay, that's one of the things, that's the second thing that he did not preclude to. And is it possible that I can call a witness?
Yes.
Okay, is Patty Sprague in the house? Right here. Okay, I'd like to call Mr. Patty Sprague up to the podium for questioning.
I don't care, I was gonna put her on anyway.
Well, I was gonna put her on too, you're right.
Well, wait, but you didn't subpoena her, you didn't bring her.
Good, that's good. You saved me some money. You saved me some money. You saved me some money because she should have been at work at 5 o'clock.
Come on up here.
Up to 5 o'clock. That's what my taxes paying for.
Hold on just a moment.
Go to that microphone right there, Patty, if you want, or sit right here, if you want to sit right here.
Wherever
Sit
you're
down, be
comfortable at.
easier for you.
So wires right
We have to swear her in.
Do you raise your right hand, please, ma'am? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Thanks, Patty.
Mrs. Sprague, how you doing, ma'am?
Fine, thank you.
Good. You signed Mr. Seibert's petitions, is that correct?
Yes. If my name's there, I did.
You know?
Yes, I recall signing them.
Oh, did you? Or, I don't know. Did you?
Well, if my signature's there, I
Oh,
did.
okay.
I signed different ones,
Okay. Okay. Well, they're only on 2 of them.
but I mean different people from time to time. I've signed petitions before.
Did you sign his petitions?
Is my name there? Let me see.
Page 1, line 3 will stipulate that she signed it.
I signed it.
Okay. It's not Mr. Seibert's signature, right?
That's mine.
So, what time of the day did you sign those petitions?
I have no idea.
Was it morning? Was it night like this? Was it
I don't remember.
early in the morning? What?
I'm
She
sorry.
she answered your question.
I don't remember.
You don't remember?
No.
Okay.
It does not ask on the petition what time to document the time.
Sir, that's not the I'm not asking you any questions. There's a relevance behind every question I ask.
I hope so.
The date that you signed them on was the 14th.
If it says the 14th, it's
George,
what is it?
what are you asking
I don't-
about
I don't-
signing? Signing what, the notary, or signing the petition, or what?
Right, what am I saying?
Notarizing the petitions.
Oh, the notary, okay.
You notarized all of his
Sure, I
petitions.
did-
You didn't sign
notarize
this.
Mr. Cybers, yes.
Okay, that's all I want to know.
I'm sorry, yeah.
That's it. That's all I want to know. Now, she's your witness since you brought her.
Okay. And you notarized Mark Kern's signature on page 1 on the 14th,
I did,
and he appeared in front of you.
yes, he did.
And you notarized Paul Seibert's signature on page 2 on the 14th, and he appeared in front of you.
He did.
And you notarized Paul Seibert's signature on page 5 on December 14th, 2014, he appeared in front of you.
I did.
And you notarized his signature on a statement of candidacy on December 14th, 2014, and he appeared in front of you and signed his name.
Yes.
And you notarized his signature on the wild bill on December 14th, 2014, and he appeared in front of you and signed his name. Thank you.
Okay, my other question is that, Mr. Seibert, he just answered my questions. He said that you signed all the petitions and you appeared before.
I mean,
As a circulator.
Then it goes another witness, I mean,
Are you done with Mrs.
Yes.
Sprague?
Oh, I was done with it. I told him that he's now her witness.
So we're back to Mr. Seibert, your question.
Yes.
Well, no,
but now you go for, you call a witness, you
Right.
put him on, then you go to your next witness, you don't.
I understand. He's
no,
back and forth.
Mr. Bird, once you call a witness and you're finished with the witness, you're finished. Okay?
I'm done.
Okay, so you're done with Sprague?
Yes.
Okay. I mean, because you were previously questioning Mr. Seibert, now you're saying you want to question him again?
Yes.
Okay. Do you have many questions?
Yes.
It's up to the board whether or not to allow it.
Over there
So.
with him? Because I don't want to leave him with him. Oh, yes, they are. I'm gonna he notarized, his signatures of those as well, and you can easily see that those are not the same signatures. Tell me, also, Mr. Seibert, do you know Elmer Sims?
Elmer Sims.
Yes, Elmira Simmons.
Yeah, they're very close.
They referring to a line and page?
Well, I'm talking to Mr. Seibert now.
No, I'm asking if you're referring to a line and page of the petition.
Yeah.
What line and page?
Sheet number 5, number 3.
Sheet number 5, number 3.
Yes.
Elmira Sims.
Yeah, I know her.
You know her? Okay. Who signed at that house? Who's the individual that signed everybody's name at that house?
Nobody signed everybody's name, each one signed their own.
Okay. Each one signed everybody's, each person signed everybody's, the same name, didn't sign everybody's name, right?
I didn't sign anybody's name.
Okay. And, were you aware that each signer must sign the petition themselves? One person cannot sign another person's petition,
Exactly.
and no one signed these petitions, right?
That's the third time he's asking that.
The-
Yeah, Mr.
I'm not asking him any questions. Sir, you need to say something to him.
Everybody that signed the petitions he circulated signed in his presence.
He's answered the question. He's answered the question. And Mr. Sprague is his spokesperson. Now,
So that means that he can interrupt me anytime.
He can object. He can
He
make
can
legal.
object.
Well, he didn't object. He just said what he did. He wanted to say what he wanted to say.
Objected 'cause they-
He didn't say
they asked
objection.
you twice.
Mr. Byrd?
He may put
It's
through-
been established that he made the statement, answered your question.
Okay. The way you submitted those petitions are in order, right? Now, the petitions were submitted where you had number 6, the statement of candidacy.
I'll stipulate. the
Ho-
petition number that way.
I am not, let me make the point.
Well,
Let me make the point.
okay.
Will you let me make a point?
Okay, Mr. Byrd, proceed, but proceed calmly and
Okay, I
expeditiously.
am. My God.
Yeah. And your question is, Mr. Byrd?
His petition papers, as I said, they wasn't submitted correctly. He had his statement of candidacy as number 6. It should be noted in ILCS that they should be.
Mr. Byrd, do you have questions?
Evidence, he should put on evidence. He shouldn't-
Yeah.
You made numerous statements there. If you have a question, you can ask it to
Okay,
Mr.
okay.
Seibert.
Mr. Seibert.
Yes, sir.
Why did you submit your statement of candidacy as number 6 in your petition papers?
Well, I really didn't know if I did.
How?
Yeah. Here it is, yeah. 6.
I said why?
Why? I don't know why.
You don't know why?
No,
You just
why?
got through serving up on the petition. You just through serving up on the board, and you didn't.
He's not asking
Right.
the question.
What is the question?
Right.
I
Question.
asked the man the question. He said he didn't know why.
Okay,
You have an. You got an
Okay,
answer.
okay. Why did you submit The loyalty oath is number 7.
Comes after number 6.
I can't hear Mr. Seibert very well. Can you move the microphone? Speak up. Thank you.
Yeah, sheet number 7, it says loyalty oath.
Why did you submit it as number 7 when it should be number 2? It states it in the ILCS
Again, he's making a
rules.
statement, ask a question. He said he didn't know why he did it that way.
Right. He answered, he's already answered.
What did he answer? I'm still waiting. What was the answer?
You can answer, you wanna answer him again?
What are you looking at?
Huh?
Why did you never?
Talking to the microphone.
I thought he already asked, he said he didn't know why he said not that way.
I said I didn't know why.
You didn't know why? So have you ever completed any petition papers before?
Every 4 years.
Every 4 years you complete your own petition papers.
Every 4 years.
So you should have known that these papers should have been 1 and 2 on top of each other.
Maybe-
That's
yeah,
argumentative,
right.
it's not a question.
Mr. Burt, you need to ask questions. That wasn't a
Okay,
question.
okay. And number 3, why did you submit the receipt for economic statement as last when it should have been number 3?
Again, I won't object, he's making statements, ask him a question.
I'm asking him a question. I said why. I'm starting off with why. I'm starting off with why. What do you want me to start
He
off
already
with?
testified he doesn't know why he numbered them that way.
You talking. Let the man talk.
I did say that,
You said what?
that I didn't know why.
You said you didn't know why to any of them, but you've been an alderman for 37 years, and you submitted papers, and you don't know how to submit these papers.
I don't object, he's
Right.
argumentative again, he's
Right.
not asking a
Right.
question.
Mr. Byrd, I mean, I think it might be appropriate for the board to make some sort of motion limiting Mr. Byrd's, questions. I mean, if he doesn't want to ask questions, I mean, the board could, cease his presentation of evidence and move on to Mr.
What
Smith.
evidence, what other evidence do you have?
Finally, Mr. Seibert, the receipt for filing is last. If you didn't know why any of these papers, why you submitted these papers like this, you should have got counsel that day.
He had counsel.
He should have got counsel that day, because it tells you in the ILCS.
Mr. Byrd, once
The
again,
argument is not an
do you have any questions for Mr.?
I am only reading what
So hold on.
what they're
If
saying.
If you
in
would
the-
like to make an argument, you will be given that opportunity
Okay.
at the end. If you don't have any more questions, say so. Do you have any more questions?
Yes, I do have
Then
more
ask, please.
questions. Mr. Seibert, why did you not circle where it says circle if you live in a city, an unincorporated area, a village, or whatever? Why?
I believe I wrote Belleville on there. Yeah, I wrote Belleville.
Why did you not circle? The question is not why you wrote Belleville,
I
but
told
why
you.
you didn't circle.
He answered the question, he said he wrote
I
Belleville,
told
that's
you, I
why he
wrote
didn't
Belleville.
circle it.
Why you did not circle this
Mr. Byrd.
misguide the voters?
Mr. Byrd, I'm sure that the board will take notice that these words aren't circled.
Okay.
I mean, so if you want to
Okay.
move on, I mean, right, and Mr. Sprague is acknowledging that they're not circled. So if you want to
Okay.
move on, that might be best.
I would just like to read what the ILCS tells us.
No, Mr. Byrd, you can make your argument at the end.
Okay, I will.
Okay.
All right.
This
thank
is the
you.
time for asking questions.
All right, that's fine.
Thank you.
Thank you. I'm done.
You're done? Okay, do you have any other witnesses you'd like to call?
Yes, I'd like to call Dallas.
No, he's a member of the board. You can't call him as witness. Do you have any
I
other
guess.
witnesses you'd like to call?
No,
Okay, do you have any other evidence you'd like to present?
no.
Would you like to, okay, so you have no more testimony, no more evidence, then you'll be given an opportunity to speak at the end. So you were resting. Mr. Sprague, do you have any evidence you'd like to submit? Okay.
Did we get these, you guys seen the same papers that we seen, number 6, number 7, and what he didn't, he didn't submit them in order, right?
Did the board already take judicial notice of the
No.
petition?
No,
No,
We did not
they got
accept
the
the
same
petitions
thing
yet.
that we got.
we need to do that. You got something else to submit there or not? He just laid it up here on the desk.
Yeah. Right. Well, Mr. Sprague has stated has no evidence to present, so if you want to go ahead and make your argument, now is the time to do so.
Mr. Seibert, I'm totally amazed at what you're trying to do tonight, which is misguide the voters of your district.
Argument, not time to arrest my client, chastise him.
If you
have an
want,
argument about the petition,
you can make legal arguments about the petitions, but go ahead.
He can't tell me what to say.
Mr. Byrd, we're not going to tolerate belittling somebody or telling them what they, your argument needs to be based on the facts here.
That's what they're gonna be on.
Okay, then keep it to that.
That's what I'm saying. That's what I'm saying. I'm one of his voters in his district, and he's trying to misguide me by submitting information that is not correctly completed and everything. So if I was to try to submit something that says he lived at 1818 North 41st Street, I was trying to misguide the voters. I will be the same thing he's trying to do. It's deceptive. And you didn't expect nobody to look through your
Again, I'm gonna
petition.
object. He's just chastising my client. He's not making any argument as to the merits of the case, why the petition's
Are
not
you-
valid.
Right.
You know, let's hear why he says it's not valid.
I am not. But here's my question. When you don't submit things that are incorrectly, people look at stuff. People are found, and you misguided the voters
I'm gonna
of.
object. He's making statements to my client. He's not making any statement or argument about the validity of the petition.
Yes, I am. What are you talking about? I'm telling you, you misguided the voters.
Miss-
You can't
Mr.
see all that
Byrd.
The
information.
issue here is whether these petitions are valid or not valid.
They're not.
Well, then make an argument, tell them.
That's
they're
what I'm
not.
doing. That's exactly what I'm doing.
Right, Mr. Byrd. Mr. Byrd. Mr. Seibert, whatever he was attempting to do with his petitions simply isn't the point. What is on the documents themselves, that's what you need to stick to, okay?
Mr. Seibert did not submit his petitions. The petitions that he submitted was not circulated by Mr. Seibert, violating ILCS 510, 310, and 410 of the Illinois Code. His signature does not match, and he signs his signature differently, which is a violation of Illinois 510, 10-4, and 10-5. Anyone who fails to sign the petition, having someone else to sign for them, is a violation of the signer agreement and the Illinois statutes 5-7, and 10-4. Mr. Seibert misguided the electors in his district by not filling the petitions out correctly. He failed to circle on pages 2, 4, and 5 whether he lives in the village, city, or unincorporated area. If Mr. Seibert was the circulator of these petitions, as if all three of the other two other petitions that he submitted were circled, and Mr. Seibert has lived at this residence and been a petitioner for 37 years, then he should have known the right and how to submit these petitions. Mr. Seibert error should be held against him for not doing this correctly. He did not submit the petitions correctly, which misguided the voters of Ward 6. Mr. Seibert is the senior alderman in Belleville. He should have known how to submit the petitions. He should have gotten legal counsel as he's gotten today. It would not have been a problem for Mr. Seibert to get legal counsel. So now to come before this committee and say that he didn't know why he submitted the petitions the way he submitted them is a fallacy. How can you come before a board
Sir,
after serving 37 years in the same position?
I'm going to ask you to move on simply because whether, like I said, whatever his intent was, whether he got legal counsel or he didn't get legal counsel, it doesn't change what's on the documents. Stick to what's on the documents.
Okay, I will. It states it. States up under Illinois codes that a candidates must file following papers except as noted, and they have the corrective actions that they supposed to file them in. Has statement of candidacy number 1, loyalty oath number 2.
Yeah, what statute are you quoting there, Mr. Byrd?
That is the statute. It's the requirements for filing nominating papers or petitions.
What's the statute?
I don't know the exact law.
Okay.
I don't have that.
Okay. Do you have anything else, Mr. Byrd?
Yes, I do.
Show it to Mr. Sprague first,
I mean,
please.
the time for submitting evidence is finished. I mean, right now,
Yeah.
we were very clear on that you were finished submitting evidence.
This is a closing
and
argument.
this is just an argument. I was very clear with you on that. So you can continue with your argument. If you're finished, we'll let Mr. Sprague, make an argument.
What's the purpose of this?
His papers wasn't filed in the corrective order.
First of all, this doesn't say an order.
Yes, it does. It has an order right there at the bottom of it.
If you wrote 1, 2, 3, 4 next.
Right. That's why it's A, B, C, D. That's what that means. 1, 2, 3, 4.
All right.
It's not a statute.
That's not
I'll interject. Mr. Spur, do you have any?
Give it to you, but it's not the law, and it's not a statute.
Yeah, Mr. Byrd, do you have any more argument?
All I've heard today is Mr. Byrd, not Mr. Sprague. That's all.
So you are finished with your
Yes.
argument?
Mr. Sprague, it's your turn.
I'll try to be brief. First of all, Mr. Byrd has the burden of proof, and he's proving nothing. He's proved nothing.
I have proved a lot.
No.
I
Mr.
can
Byrd,
object, right?
Not you.
And he was
you had
objecting
your
to
argument.
me?
This is the closing argument.
Oh, he in the closing
Yeah,
argument?
you have,
Okay.
now it's his turn.
Mr. Byrd has proved nothing. He alleges Mr. Seibert didn't sign the petitions he circulated. Mr. Seibert testified.
No,
he signed
I
them.
showed that Mr. Simon.
Okay,
Notary testified that he signed in her presence on those two sheets of the statement of candidacy and the loyalty oath. Only thing Mr. Byrd gave you was a registration card that he signed 40 years ago when he registered to vote. I guarantee you, if you go look at my registration card, the signature's not the same. He brought in nobody to say that Mr. Seibert wasn't there when I signed their petition in front of him.
That's my exact
only
point.
tried to question, one signature, some lady, Mr. Seibert said he was there personally. She signed it in front of him. He brought no witnesses in. He proved nothing. As to the circling of the city, it's not required. All that's required is,
What section are you, what part of the law is he?
would you give him,
Okay.
would you give him a chance? It's his turn to give the closing arguments.
10 ILCS 5-10-4 says the bottom of each sheet of such petition shall be added a circulator statement signed by a person 18 years of older who is a citizen of the
I
United
got
States,
that.
stating the street address, rural route number, as the case may be, is the county, city, village, or county, state. And he stated that. He stated he lives in Belleville. That's cross out city, village, unincorporated area, something added by the state board of elections, is not required by the statute. As to the numbering of the petitions, the statute is kind of confusing. It's not all, the petitions have to be numbered. Mr. Cyber's numbers, the petitions are numbered. The petitions are on top, they start at page 1, and they go through page 5, and then he numbered his statement of candidacy, loyalty oath, and receipt for economic interest statement. They may not be required to be numbered, but there's nothing in the statute that says they're not part of the petitions, but the petitions are all numbered consistently. There's nothing in the statute that says how you put that stack of papers together, whether you put the statement of candidacy and the loyalty oath or the receipt for filing economic interest statement on top, or you put it on the bottom. He put it on the bottom and he numbered it just so all petition sheets were numbered. There's no case law that says you can't do that. There's no law that says you can't do that. And there's no law that really says, it's not really clear whether the petition statement of candidacy and loyalty oath are part of the petitions or not part of the petitions. That's why it's done that way. You put it in the back so everything's done so you're safe. So Mr. Seibert has complied with the law, and in spite of that, there's a whole series of cases, and the law has evolved in Illinois on election objections where they talk about substantial compliance was sufficient to satisfy even mandatory provisions of the election code. The only thing we'd have to talk about substantial compliance here is his circulator's affidavit. He put down his address at the bottom of his affidavit. He puts down he lives 700 East Adams, Belleville, Illinois, and the purpose of identifying that is so anybody that wants to look can identify who the circulator was. You don't have to circulate city, village, or incorporated town. That's just something that state board has, but it's not any place in the statutes, it's not any place in the case law. So Mr. Byrd has proven absolutely nothing, and even if you think that you have to circle city, he has substantial compliance because he gives you his street address, so anybody interested in finding who the circulator was has their street address, and you know that you give your address to 700 East Adams, Belleville, Illinois. And therefore, his petition should be denied.
Do you rest?
Mr. Sprague, does that conclude you? That you're concluded?
That's my conclusion.
Okay.
Okay, so we move
Do
to.
I have a chance to?
No,
No.
you had your
Oh,
argument.
All right, that's fine. Okay,
Okay.
that's fine.
We go to deliberations. Request of the hearing, based on Mr. Byrd, we heard the arguments. The one thing I would say is, his questioning of the petitions, he brought in nobody, no witnesses questioning the signatures. I'm not a handwriting expert, but that didn't look all that different, and certainly Mr. Sprague's point of 40 years ago when he first signed his voter's thing or whatever, 50 years ago, whatever it was, I can't certainly testify here that that's not his signature. There's a lot of similarities to it, but I'm not an expert, nor did he bring an expert in.
Make a motion that they,
That we deny.
request be denied.
We have a motion by Mr. Musgrove. Do I hear a second? I'll make the second. We have a motion and a second to deny. Any further discussion? Any further comments by anyone? Roll call. Mr. Musgrove?
Aye.
Dallas? Aye. And the mayor votes aye. The chair votes aye. These requests for, by Mr. Byrd have been denied, and I'd ask for a motion for adjournment.
Actually, quickly, I will just say that I will, I'll get formal decisions prepared, signed, and I'll mail them to the parties.
Motion to
Okay.
adjourn?
Motion by Alderman Musgrove. Do I hear a second? Second by Mr. Cook. All in favor of adjournment signify by saying aye.
Aye.
Aye. Opposed? Motion carries.